What's up, folks? Sorry, I'm a little bit late, a little bit behind. I'm here now. Oh, snap. Got a couple people in the chat already. Appreciate you all joining me on this fine New Year's Eve. Won't be going too long. I will try to get through this as quickly as possible because I know a lot of you probably have some partying to do tonight, celebrating the new year coming in. So I'll try not to keep you all too long here. So the filing I'm going to be going over tonight is one that I have to say surprised me because of the sheer amount of stuff that is just packed into it. Now, that being said, it doesn't mean I'm going to be going over the entire document because there is a lot of stuff in this filing that is completely unnecessary, and I'll explain why once we get there. But this document, this particular court filing is one of the newer ones. We'll be going over this one, and I'll also be going over the motion to dismiss, and that'll pretty much get us up to date in regards to what is going on with this case until there's another new filing. So we'll be pretty much caught up because, like I said, the other stuff before that I was looking through, I took the time to look through previous documents, and I didn't find anything that I would say was worthy of covering in a stream because a lot of it was repetitive. A lot of it was stuff that if you all have been watching these streams, you all are probably already know. A lot of it is the same language, it's the same stuff over and over again. So I didn't want to tread over that old ground again. I didn't want to beat a dead horse. So I just wanted to really focus on stuff that I thought was really interesting, anything that would show any kind of change in the case. And the reason why I chose this particular filing, and you're going to see there's a lot of redactions in this filing, is because it is absurd the amount of stuff that is in this filing. Like I couldn't believe it. It ended up being something close to, I think it was like 95 pages. Now, like I said, we're not going over all of them. We're just going to be going over the stuff that I think is pertinent to mention, and then we'll go over the motion to dismiss. So that being said, we'll wait for a couple more people to kind of join us here, and then we'll get started. So I see right now we have about, what do we have here? Looks like 14 people. Wait for a couple more people to come in, and then we'll get going. And of course, for anybody that wants to, I'm going to leave this up. That's another thing too. For anybody that has to go or doesn't get a chance to watch this entire thing, I will be leaving it up as I do with these kinds of streams. So anybody can come back to it, watch it at their own pace. If it ends up being that they have to leave beforehand. So let me go ahead and get this ready here, and we will get started here shortly. But yeah, this is pretty wild. Like I said, yeah, 95-page filing, but we won't be going over that. We'll be going over probably like the first 10 plus pages, because those are the most, like I said, pertinent ones to mention. And then on to the most recent filing until something else comes out, the one that was filed earlier this month. So go ahead and bring this up here, and we shall get started. Let's see. Find it here. Yeah, I don't anticipate this will take too long, hopefully. So here we go. And let's see. I'm trying to find it here. Let me go back here. Here we are. All right. Here we go. All right. It's not letting me pull that up. Okay. Here we go. Here we are. All right. All right. So here it is. Now, as you can see, there's going to be a lot of redactions in this one, like an excessive amount, because I had to basically go over this with a pretty fine tooth comb. It took me a while just to redact this one, as you can imagine. So you're going to see a lot. You're going to see a lot of redactions in this. Now, this, of course, is done to protect the identity of people involved and stuff like that, even though by now everybody knows the real names of the people involved in this. But just in case, so I don't have to worry about anybody trying to file some kind of privacy complaint on this video and trying to take it down, I went ahead and redacted, like I said, even though a lot of this is public knowledge. If you look up this case number yourselves, you'll be able to find it. with this court. But we will now go ahead and proceed here. So plaintiff's sure reply in opposition to defendant's motion to dismiss or transfer venue. So as we know, and we talked about this before in the previous stream, that what Delirious's lawyers were trying to do was essentially get the case dismissed, or at least, get the case dismissed on jurisdictional grounds, or at the very least get the transfer venue, which would then allow them to try this over in North Carolina as opposed to Illinois. Now, that could be some kind of tactical, some kind of strategic, I guess, move on their parts. I don't know. That's what it seemed like from the filings that we had seen before. That seemed like they felt that if at least the venue is North Carolina, that it would be easier for them to have access to, witnesses and things like that, or at least so much was implied or said in the documentation that Delirious's lawyers filed. So that's what this filing is about. Is basically Ohm's lawyer opposing that motion to dismiss or transfer venue. Now, keep in mind that Ohm's previous attorney basically said, "I'm out." He basically withdrew from the case, and this is actually Ohm's new attorney that is making this filing. And I find there's some things that I have some opinions about regarding the way that this attorney is doing things that I find interesting, but we'll go over that. So it says, now comes the plaintiff, Ohmwrecker, by through his attorneys, Edmondson Davis LLC, and for a sure reply memorandum in opposition to defendant's motion to dismiss and or transfer venue, he asserts as follows: the complaint seeks redress for a series of defamatory social media posts systematically designed to inflict the maximum damage to plaintiff's personal and professional life. See complaint generally at all relevant times the plaintiff has lived and worked in Illinois. Complaint at Paris 813, 105, 103, 105. Defendant has known the plaintiff for years and has known that he lives and operates his business in Illinois. That's basically Ohmwrecker's declaration. Defendant's motion to reply suggests the defendant's primary residence or location of defendant's girlfriend, or for some reason is determinative. Defense counsel is mistaken. Defense counsel ignores the fact that this is largely a defamation case. Accordingly, as a matter of law, the principal injuries occurred in Illinois, and then he cites a case here. Venue is only proper in Northern District of Illinois. One venue is only proper in Northern District. For venue purposes, a civil action may be brought in. One, a judicial district in which any defendant resides, if all defendants are residents of the state in which the district is located. See, so that's interesting, right? So even by what the lawyer is citing here, right? A judicial district in which any defendant resides, if all defendants are residents of the state in which the district is located. Little bit an interesting it's kind of an interesting thing, right? So it says it's saying that or at least the way I infer this is that people would have to reside in the district, but also there's that they don't. I guess it could be wrong, but it says a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred, or a substantial part of the property that is the subject of the action is situated. Or see, what's interesting about all this is the fact that the Delirious didn't start this. Delirious has made a lot of mistakes, and there's plenty to criticize there. And I think there's a lot of, let's be honest here, he's fucked up a lot. There's a lot of things he's fucked up. There's a lot of things he's messed up. And I honestly, don't know which way the wind will blow on this case. Lord knows there's been plenty of mistakes made on both sides where honestly it could go either way, or it could just get thrown out entirely, right? It's who knows where all this is going to go. But to say that, it's kind of hard to argue that, a lot of this stuff occurred in the state of Illinois when you're talking about two people that really went at it online. They went at it for all intents and purposes, in my opinion, they went at it in neutral territory, in virtual territory. So there's that, right? If there's no district in which any action may otherwise be brought as provided in this section, any judicial district in which any defendant is subject to the court's personal jurisdiction will respect with respect to such action. So, I mean, to me, they're citing. It seems like they're citing Illinois law, but it seems like it's something that would still, even by, at least from what it says here, it seems like this would be subject to Delirious's jurisdiction. But maybe I'm just misreading that. Again, I don't know. I'm not a lawyer. In the reply, defense counsel mistakenly argues that after Walden versus Fior, even for a defamation case, it matters not where a plaintiff was actually harmed, where their personal relationships will feel the impact, nor where their professional life and business have been appended. Not Walden NT LLC, nor any other case defense counsel reads 28 USC. Out of existence venue is still proper in a judicial district in which a substantial part of the events or omissions giving rise to the claim occurred. See, but the thing is, the problem with that, right? With his attorney trying to argue this is that there's, again, the stuff that Ohm said obviously is stuff that was, you could argue those events were made in Illinois, right? When it came to the stuff that he said, just like you could make the argument that when Delirious did what he did, he would be under the jurisdiction of, North Carolina, right? Because that's where the events occurred on his part, right? So here that is only the Northern District. In multiple post-Walden cases, the Northern District has repeatedly held that the principal injury giving rise to defamation claim occurs where the plaintiff's reputation would suffer the most harm, where she lives and works, and where the people with whom she has a personal commercial relationship reside. See, again, I see what his lawyer's trying to argue here. But again, the biggest problem, this is not, I think it would be a little bit more clear cut if Ohm owned an actual like storefront or something like that, or actually had a business that resided in Illinois, and something happened to affect it like that. Like, but the problem is a lot of this business is pretty much done online, which doesn't really have, for all intents and purposes, doesn't really have any kind of it's really hard to argue any kind of jurisdiction there, right? Because you're talking about the internet. What if Delirious lived on the other side of the world? I mean, that's a whole nother can of worms you're opening up there. And the thing is, there has to be I think something a little bit more concrete. I mean, when it comes to defamation, I know that obviously jurisdiction doesn't necessarily always matter if it's enough, again, to harm his business. But the thing is, it's also a matter of proving how much your business was harmed by all this. And the thing is, you all are going to see later on in this filing, there's a point that is referenced of where Ohm claims his business was harmed. But I'm just like, okay, that's still going to be pretty hard to prove, right? We know that he has said that Ohm has claimed in previous filings that he's lost all these kinds of opportunities, that his viewership has dropped, all this stuff. Now, if you all saw the previous stream, you know that I showed that regardless, even before the lawsuit, long before any of this even kicked off with Delirious, Ohm was already losing subscribers. He was already losing followers. He was already losing viewership. So can you say that a lot of what we're talking about, an instance where his channel, everything, his stuff online, his stock, so to speak, was already going downhill before Delirious. Now, Delirious, there's probably heading in a downward trajectory regardless. So, thank you, Sen. Sen says, Happy New Year, Johnny. I appreciate that, buddy. Thank you for the 10. Appreciate that. Thank you. So we'll continue on here. Let's see. In multiple post-Walden cases, Northern District has repeatedly held that the principal injury giving rise to a defamation claim occurs where the plaintiff's refutation reputation would suffer the most harm. Okay, we already went over that part because that is where a person will suffer the most damages arising from reputational harm. You're talking about a guy who operates his business from home and just exclusively online. Now, it's not to say that that still can't that still cannot affect, right, a person's business, online business if they're doing their business out of their home. But again, I think it's a little it becomes a little bit harder to prove when it's the nature of what they do, right? You're talking about a guy who streams, and although he does, I believe, sell some merchandise too, a lot of his income is really reliant on obviously how often he streams. I'm sure donations, things like that. He has a partnership with Twitch, as far as I know. His channel is monetized on YouTube, so his his income is really primarily dependent on his content production more than anything else. And obviously who watches, and again, yeah, the argument can be made that the stuff that's gone on has affected all that. But as we saw before, as I stated before, with what we showed in his social blades and stuff like that, he was already on a downward trajectory. I think at best his lawyers can argue that yeah, that just accelerated the drop in viewership and all that stuff. Maybe it's possible to somehow prove that. But again, this is something that was happening long before. I don't think they can possibly argue that as a result of whatever happened with Delirious, that this did this kind of e, you know this kind of irreparable harm to his reputation, his channel, and his business and all that. I don't think you could just solely argue that when it was, like I said, it was already on the way there, slowly itself. Like I said, maybe you could say it accelerated it, but as far as overall, yeah, I don't think so. But again, just my opinion. All right. So it says in Basel, a post-Walden defamation case where personal jurisdiction case was challenged, the plaintiff filed defamation per se and false light claims related to a story defendant had published in Basile shortly after the offending article was published. Plaintiff moved to Illinois. Plaintiff's complaint alleged that the article defamatory statements caused harm to her career in Illinois. It caused her reputational harm and tremendous stress for which she sought treatment in Illinois. The Basel defendant argued venue was improper in Northern District because the defendant corporation was not an Illinois resident and events leading to the article's publication did not occur in Illinois, with reference to 28 USC. Even after the Walden Northern District denied Basel defense motion to dismiss with respect to defendant company, holding venue was appropriate in Northern District because the injury occurred where plaintiff's reputation would suffer the most harm, where she lives and works, and where the people with whom she has personal or commercial relationships reside. The same reasoning applies here. The Basel court similarly denied defendant's motion to transfer venue, noting there is a strong presumption in favor of the plaintiff's choice of forum if it is where the plaintiff resides, and transferring this case to California would merely shift inconvenience from one party to another. Also noting in diversity cases, it is often advantageous in federal if the federal judges who preside over cases are familiar with the applicable state law. Here, Illinois law, therefore, the factor weighs slightly against transfer. In addition to the fact that principal injury occurred here, defendant Delirious purposely directed his activities at Illinois by one, directly contacting Illinois resident to defame the plaintiff. Now, if you're wondering who this redaction is, this is actually the girlfriend known as Goose. Obviously redacted the real name, but we'll just call her Goose. That's the one that was claimed to have been a part of the sex tape. That's who that's referring to. That's that girlfriend from like 17 years ago, in case y'all are wondering. So moving forward. Two, by publishing the plaintiff's Illinois home address and encouraging defendants' million-strong Delirious army to harass or commit violence against the plaintiff for supposedly abusing minors. Okay, I want to address this real quick, right? This particular part right here. There is no, I mean, you can, I think at best, Ohm's attorneys can try to make that implication, but there is nothing that I've seen as of yet. I'm not saying it doesn't exist. Maybe it'll come out later. I don't know. But as of yet, from what we've seen publicly, from what I've seen in filings, from what I've seen out there, I have not seen anything remotely close to this at all from Delirious's part. I have not seen anything, that says, anything from Delirious saying, hey, go harass, go, commit an act of, violence, against Ohm or anything like that. I haven't seen anything of the sort. I'm not saying it doesn't exist. I mean, there's been, one could say maybe there's been implications, right? I think TJ, when he was on here last time, he had said, oh, the whole thing with anybody wearing this mask should be shot. That's not, I mean, you could say that's maybe some kind of implied, threat. Maybe you could say there's certain things that he's put out there that's maybe a wink, nod, but nothing direct. Nothing that I think that they'll be able to prove in court beyond a reasonable doubt. Like I said, unless there's something out there that I just not, I myself haven't seen yet, or it just hasn't come up. Maybe in discovery, maybe there'll be proof of that comes out. But as of right now, there's nothing out there. So I get what Ohm's attorney is trying to do here. He's trying to paint this kind of narrative. He's just doing what an attorney is trying to do, but there's nothing that unequivocally proves this claim that I've seen. Okay, so we'll continue on here. By exposing the identity of plaintiff's girlfriend, referred to here as, and this is another girlfriend who also lives in Illinois, inviting retribution against her as well. Again, haven't seen anything to prove that this is a pretty bold claim. I have not seen anything that unequivocally proves that. So, and there's nothing that you're about to see here in the proof that is posted that proves that either. So, defendant defamed plaintiff to plaintiff's ex-girlfriend. And, obviously this is Goose for, Mr. Delirious falsely accused plaintiff of having sex with a minor, filming the sexual encounter without consent, and of publishing the non-consensual video as RP. Doc number 1, paras 31, 49, 50, and 61C, for example, one of Mr. Delirious's offending tweets made from one of his Twitter accounts at Ohmlight, right? So as we know, this one was, I believe, proven to be one of Delirious's alt accounts. We already know that has been confirmed. As you can see, TJ was mentioned in this, or he was responded to in this tweet. It says, why hasn't anyone questioned the email leak of Ohmwrecker on the Kiwi page, where he was getting death threat caused by a sex tape he leaked on a torrent site? They were saying the girl he had sex with was underage. Look it up. He tried so hard to hide the tape. Said Mr. Delirious's additional offending speech is below. In 2005, Ohmwrecker was accused of making and threatening to use RP against his ex-girlfriend Goose. Goose was believed to be underage at the time. Ohmwrecker was accused of using the photos and videos he made of her and spreading them on torrent sites. Another thing that hasn't been proven, to the best of my knowledge, it's just been, it's just something that has been said out there, right? So the individual defendant refers to above as Goose is, and of course the name is redacted, plaintiff's ex-girlfriend. Ms. Goose currently at the time of the offending speech is an Illinois resident. Showing Mrs. Goose's address at, and this is another thing too, and this is something I criticized with the previous filing too. I don't see why these attorneys feel the need to, for one, Goose, as far as I know, unless maybe Goose might end up being a witness in this case, right? But as far as I know, she is outside of being mentioned by Delirious as the person in the tape. She has that's about as far as her involvement goes with the case, as far as I know. Now, it's possible that she could end up being a witness. She could end up making her own declaration for Ohm. She could end up signing some kind of affidavit. That remains to be seen. But I don't see the need to not only, I understand posting her real name in this document because it's a legal filing, but I don't see the value in posting her home address in this document. It's like, what? Okay, why is that? Why does why is it that, what is it about her home address that, why is that relevant to any of these matters, right? I think the only thing you need to provide, because it is a legal filing, is her name. I don't see the value or any good reason why her address should be posted in this particular filing, right? It's funny because for all the doxing that Ohm claims, right? He's willing to put, and granted, these are public filings. I understand that certain things have to be posted, but it's just like he's put more personal, I think, at this point, and you're gonna see, it seems like he's put out more personal information about people than even Delirious has. That's the way it comes across, at least in this document. I'm not, of course, but this isn't a court filing. It's a little bit different. So I'm not saying he's doxed anybody, but on the surface, it would look like that to anybody else, right? Or some might interpret it as that, I'm not saying I do, and I'm not saying that he did, but I'm just saying to some, it might seem that way, looking at this on a surface level, right? So we have here, let's see, search for made contact with his ex-girlfriend of mine from, okay, so Ohmwrecker, declares, let's see, says here, it says, defendant actively searched for and made contact with an ex-girlfriend of mine from 17 years ago regarding the false allegations of releasing RP and having intercourse. In the released video with a minor, my ex-girlfriend is a lifelong resident of Illinois. In a direct message below on the left, the defendant from the Twitter handle Pizza Pirate, which again was confirmed to be Delirious, right, by Liz Katz, right, admitted that he actively sought out and actually spoke with Illinois resident, and that being Goose, regarding this completely fabricated allegation of revenge porn. So these are the DMs. Chilled, I think these are the ones that were, I believe some of these were sent to Chilled, who I think is in the chat. But so we have here, fans saying anything they want doesn't mean it's true. We're all trying to live our lives, even serial killers, rapists, and places like I said, you're free to go after Ohm. Doesn't bother me, but you can't prove that the allegations are false, and that's what's worrying you. I've shown multiple times where Delirious has lied and misled. I have connected with Goose and will ask about the tape. I doubt she was underage, but I'm sure it was RP. So, of course, this flies in the face, right, of any claims that were made previously by him saying that he had heard that she was underage, right? So he's not telling the full truth. You can't prove they are true. And then we have here, he links a web archive because, that's a little illegal. This is from the Mystic Names, the way back. This is, this is Ohmwrecker, obviously. It's just his name is redacted there. The Wayback Machine shows his old website post. I see this is about his whole drama about the forum, which started because he uploaded that sex tape, which I agree with you. I think it was revenge as well. He doesn't want this part of his life to come to light and has blocked many people that has questioned it without ever explaining. Okay, in the direct message on the left, Mr. Delirious admits that he connected with plaintiff's ex-girlfriend. Goose, Mr. Delirious' message on the right shows him directly accusing Ohmwrecker of creating a sex tape without his partner's consent and uploading it, i.e. committing RP. Defendant Delirious published plaintiff's Illinois home address, encouraging followers to pay him a visit. Again, this is a claim that's made that I have not seen really substantiated by any of the evidence. Now, you could say that maybe there was the implication, there might be an argument that there was an implication there, that maybe there was a little bit of a wink, wink, and nod, nod. Hey, I'm not telling you to do this, but but by me kind of putting it out there to you all, that's exactly what I want you to do. But again, there's no way. Good luck proving that, right? So it says, as an online content creator, plaintiff has gone to great lengths over his 10+ career to hide his home address. Doc number 1. Plaintiff's efforts to conceal his identity included operating online under a pseudonym, never showing his face while streaming, never giving his address to fans, not attending any live events, and habitually following various search websites processes, including those for peoplefinder.com and webpages.com, to have his address and identifying information scrubbed from the internet. So here's the other thing, too, that I don't care for what his attorney's doing here. And I think that if Delirious' attorneys are smart, they'll be able to argue the fact that Ohm's information was already publicly known long before Delirious got a hold of it. It was already on Kiwi Farms, and I'm sure there's other sites out there that probably do have it, right? So it seems to me, though, that the idea here is to not, I can't say that it's necessarily to paint it that Delirious was 100% the person, was 100%, to make it seem like Delirious was the person that first put his information out there on the internet. But I think it's definitely trying to spin the narrative that he was the main proponent of getting Ohm's information out there to the masses. And the thing is, the evidence, like I said, the evidence that's out there just does not back that up, because we know that there was plenty of other people. Granted, the difference is Delirious has a much bigger fan base, but the way they're presenting is that, Delirious, because he has such a huge fan base, he was the one basically signal boosting all this information publicly. Now, there were instances where Delirious did screw up, right? Where he did mention, I think he mentioned the second girlfriend's actual full name. And I think that's the one thing that he tweeted out, and he shouldn't have done that, right? He essentially at least doxed her real name. But as far as the first girlfriend is concerned, right? The RP, the one regarding the RP and all that, I've seen no evidence where he publicly was directing people towards her specifically, outside of saying, hey, that this exists. Like, I haven't seen anything that shows that he was putting out her first and last name. And if he was, it seems like the only time any of that stuff was happening was really in private. It was in DMs. It was not on, public tweets or comments or anything like that. So, not that I'm saying that necessarily makes it better, by the way. I'm just saying that they're making it seem like it was much more heavily publicized than it actually was. So we have here: a plaintiff masked his identity out of concern for his safety. Defendant Delirious somehow found plaintiff's Illinois home address, full name, and multiple photographs of him. Okay, so now they're making it seem like, oh, I don't know how he found this stuff. He somehow found this stuff. Look, everybody who knew about Kiwi Farms and knew who was knew about this. So it's not like somehow he found this stuff. This stuff was already publicly available. It was already out there. It wasn't that Delirious had to go and dig really deep for it. You know what I mean? Probably somebody sent it to him, for all we know. There's no way to, or maybe he did go looking for it. But again, how do you prove that, right? For all we know, somebody could have hit up Delirious and be like, hey, here's all of Ohm's personal information. It's all on Kiwi Farms. Here's the link. Now, what Delirious did do is he did share that Kiwi Farms link behind closed door. That is, that much has unequivocally been proven. So, let's see. Defendant Delirious then repeatedly posted plaintiff's private information across the internet while encouraging violence and harassment. Unproven. This has not been proven. This is just an allegation. This, you can't, you could probably say maybe, you could probably try to argue that maybe that was the implication, but good luck. From his followers, remembering upwards of 13.3 million on social media, known as Delirious Army, in direct messages below. Defended from his social media account, Hopper98 sent a direct message to a fellow gamer, Angel Pratel, warning her that, Ohmwrecker released a sex tape that he made long ago. He received so much hate from the phone calls because they said she was underage. She is not a good person. So again, this kind of contradicts what Delirious said in other DMs, if this is him, which I'm not sure if this one has been proven to be him. Maybe it has. I'm not going to say. So we'll just say allegedly, because I don't think this is one of the ones that Liz Katz posted. So maybe it is him. Maybe it's not. I don't know. But we'll continue on here. But yeah, as far as this goes, this claim up here, yeah, I haven't seen Delirious say, hey, go do something to the guy. So then we have this, right? This is from the Hopper 98 account, right? I've seen that you recently tweet Ohmwrecker, be careful of him. He has released a sex tape that he made long ago. He received so much hate from the phone calls because they said she was underage. Just emails with pictures that have been sent to business associates with information stating that the girl was underage, and that this is like I guess an excerpt from the Kiwi Farms thread, which is shown right here, right? Search him on Google to see everything Ohmwrecker Kiwi Farms. See, he also cheated on his girlfriend and never told her. There is a video on the forum. In the above message, the photograph with the message is difficult to see. In the address, difficult to read. However, the same information with the different rotating photograph of the plaintiff is shown below. In the excerpt below, defendant included plaintiff's real Illinois home address. See, this is disingenuous, right? In the excerpt below, defendant included plaintiff's real Illinois address, full name, and date of birth beneath the picture. The identifying information is redacted here, but provided in the court under separate covers. Now, they're making it seem that, in a sense, yeah, he did share it, but also at the same time, you got to remember that that was part of a Kiwi Farms post that he was sharing. So, I mean, it's a semantical argument, right? It is a semantical argument, but if we're being honest about the whole thing, right? It almost seems like by presenting it this way that they're trying to imply that it was essentially like him, right? Like he's the one that put it out there when it was already out there in this Kiwi Farms thread. Now he did spread the Kiwi Farms thread. That I think it would have been more. I think they should have presented it more like that, right? That he was, they're saying that he included plaintiff's real Illinois home address, phone name. In a sense, he did, but at the same time, you got to remember this is all part of a thread that already existed long beforehand. Now, this is stuff that I redacted because, Ohm is the kind of person that would probably file a privacy complaint. So we have a clip here. This is from the Kiwi Farms thread, right? The defendant cannot broadcast plaintiff's Illinois address knowing that this disclosure would end with harassment and threats coming to plaintiff's doorstep, and then claim surprise that an Illinois court lacks jurisdiction over him. Again, there's no way. That's all speculation. Like I said, they could probably try to argue, the implication, but it's speculation. At the end of the day, you never know what people are going to do. Like I said, and at no point in time did I see any call to action on Delirious's part for people to go and, not only harass him, but try to, stalk him or show up at his house. Now, he messed up already, again, like I said, by telling people to go and try to find the thing. So, again, they could turn that into, like I said, they can make that the implication, I guess. It's just like, oh, look, he's telling people to find this RP, which he shouldn't have done. And that's where I think he really screwed up, was trying to get people to find a video, a sex tape of Ohm. So defendant docs plaintiff's girlfriend. This is another girlfriend for the same reason that Ohmwrecker had painstakingly tried to conceal his identifying information. Girlfriend took the same precaution. Ohmwrecker's girlfriend knew that if her identity were revealed, her safety would also be at risk of her association with Ohmwrecker, in addition to publishing the girlfriend's full name and address. Defendant Delirious, which again, they're making this claim, and maybe they have evidence. Maybe they have evidence to support this claim. I have not seen it. It's not in this document. So they're saying that he published her full name and address. Now, he did publish her full name in a tweet, and they do show that, but I don't see anything that shows that he posted her address. I'm not saying it doesn't exist. I'm just saying I don't see it here in this. Maybe they have it. Maybe they don't. Maybe they're hoping something will come out in discovery that will show that will unequivocally prove that. But as far as this goes, I have to take it as just a allegation, right, that he did that. Though he did post her full name. That is true. And you'll see it in the tweet. You won't see the actual name. Obviously, it'll be redacted, but that apparently did happen. Okay. Also broadcast the first and last name of plaintiff's girlfriend, address a defendant, tweet publishing girlfriend's full name is below. Defendant tweeted from his account, H2O Delirious, an account that Undisputed is solely controlled by him. Yeah, there's no doubt about that, right? And here's the tweet, right? And apparently he did post her full name here, allegedly, right? Screw him. So I mean, we'll give him this one, right? That he did post her full name, right? So I'd never seen this I think I might have seen this tweet in passing, but I don't know. I can't remember. So let's see. So it says Delirious had no reason to reveal the girlfriend's real first and last name other than to invite his followers to attack her to make her life less safe and by extension to hurt the plaintiff. That's speculation, right? We don't know that. We don't know that for a fact. But obviously a big mistake by Delirious to do that, right? To post her full name in the situation. Probably something he shouldn't have done. But to say that it was, to invite her to attack, I mean, but then again, it could be implied, hey, hit her up, right? You could probably imply him putting out her name, her first and last name was, hey, hit her up. She'll give you the details or whatever, right? Shake her down or whatever. Even though he didn't direct people to do that, maybe you could argue, right, that that's what he was implying. Who knows? So it says in 2021, in response to defendant's actions, plaintiff filed multiple formal reports with the Elgin, Illinois Police Department, as well as an IC3 report with the Chicago FBI field office as part of their investigation. The Lisle, Illinois field office obtained a statement from plaintiff in his Illinois home. Defendant Delirious has purposefully directed his harmful activities in Illinois in such a manner that he cannot claim surprise that the plaintiff has filed suit in this jurisdiction. Defendant's repeated choice to broadcast plaintiff's plaintiff's Illinois address and Illinoisian girlfriend's identities are further reasons why the court has personal jurisdiction over defendant. So it's interesting how they phrase it, right? They say choices to broadcast plaintiff's Illinois address. Now, there's stuff that he obviously has done in private to show, to direct people a certain way, but they're trying to make it seem like by and large, like he was out there every day posting, right? Posting the information out there, on his Twitter every day. Like I know that he actually, I think he just posted her first and last name, TJ. I don't think he posted her address. I know he did post the full first and last name. And if he did, hey, if that's out there, then I will gladly correct the record on that. But I would think if that were the case, you would have put it in this filing. It should have been put in this filing. Redacted, but it should have been put in this filing to show that. But I know that in private, obviously, Delirious was directing people to go to Ohm's Kiwi Farms. That pretty much is undisputed, right? To go check out his Kiwi Farms. And he was telling people to go and try to find this the sex tape, which is that stuff that he shouldn't have done. And that's the stuff that I feel is really going to harm him when this moves forward. But I think it's a little disingenuous to make it seem like he was going out of his way to post all the private, and personal information of these other people, like, putting it out there in a much bigger degree that is purported. Like I said, I think the biggest misstep again was the one girlfriend's first and last name. Probably shouldn't have done that. But as far as the other girlfriend, as far as I know, like I said, he didn't do that publicly as far as I've seen. So let's see. This district has consistently maintained that Illinois has a strong interest in providing a forum for its residents to vindicate harms from out-of-state actors. And they said a case, as a matter of law, a substantial part of the events or omissions giving rise to these claims did not occur in North Carolina. Defendant has failed to establish that this case should be transferred pursuant to 28 USC 140 140 1404A. Defendant's venue motion next argues that the transfer is appropriate pursuant to 28 USC, which provides for the convenience of parties and witnesses in the interest of justice. The district court may transfer any civil action to any other district or division where it might have been brought. As the movement, it is the defendant's burden to establish that the Eastern District of North Carolina is a proper venue that is clearly more convenient under Section 1404A. See Judge Unigroup Incorporated 2017. The burden is defendants as the movement to demonstrate that the balance of the factors weigh heavily in favor of transfer, that transfer would not merely shift inconvenience from one party to another. Emphasis added. In assessing whether the defendant has met his burden sufficient to warrant transfer, Basile is again instructive. Basile, the defamation defendant, similarly argued that the transfer from the Northern District was proper pursuant to 1404A in the interest of justice and convenience of the parties. Basile 2016, with respect to evaluating the relative ease of access to sources of proof, the Basile Court noted that in the age of electronic documentation transmission, the parties in the court can easily access any necessary documents in Chicago just as well as in the proposed transferee district. A similar analysis is appropriate here. There is no documentary or physical proof uniquely located in the Eastern District of North Carolina, which would suggest transfer is necessary or more convenient for any party. This factor does not weigh in favor of transfer. Denying the 1404A a transfer motion, the Basile Court stated that while many of the events surrounding the article's publication took place in California, the principal injury to the plaintiff took place in Illinois. As the defendant failed to establish the balance of the private and public interest, strongly favors transferring the case to the Central District of California. The motion to transfer is denied. Similarly here, the principal injury to the plaintiff occurred in Illinois. In reply, the defendant also fails to meet his burden of demonstrating that witnesses with significant testimony exist who would be greatly inconvenienced by litigating in Illinois. Noting the standard employed here, stating on balance, the private interests do not overcome the strong presumption in favor of plaintiff's choice of form. As a general rule, a plaintiff's choice of form should be disturbed only if the balance of public and private factors strongly favors the defendant. Court should not limit its investigations to a review of which party can produce a longer witness list. Rather, a court should look to the nature and quality of the witness testimony with respect to issues of the case. Emphasis added, with an eye to the anticipated nature of the quality of expected witnesses' testimony and substance of the case, the plaintiff and Illinois residents is likely the most significant witness. Plaintiff's testimony concerning the personal and professional harm suffered as a result of the abusive social media campaign is critical to meeting each element of the defamation-related claims and supporting a claim for damages. In many cases, the defendant's testimonies would be important as plaintiff. However, here the bulk of the evidence against the defendant is found in his online admissions and likely from responses to subpoenas to Twitter and other corporate entities. Okay, so that'll be interesting, right? If they subpoena Twitter and are able to find stuff that is a bit more concrete, right? Because as we know, Ohm's claimed, that, his people at Twitter, the person he was in contact with Twitter, 100% confirmed to him all this stuff, right? Would be interesting to see if they're actually able to get anything that proves that beyond a reasonable doubt, right? About these accounts and stuff like that. But even then, I think the biggest thing with that was the whole, Delirious, allegedly threatening a kid and stuff like that. I don't know how much more getting anything subpoenaed for Twitter, how much more that's going to hurt or help Ohm's case when there's already been enough that's been admitted by, Liz, right? Liz Katz in her video that will help Ohm in this particular instance, right? The whole stuff of him essentially guiding people or, telling people, hey, encouraging people to go find a sex tape and stuff like that. Yeah, that I think is enough. I'm not sure how much more, because remember the stuff with the whole, allegedly threatening the baby and all that stuff, that has really nothing to do. That's a separate thing from the defamation here, right? The defamation case that we got going on here. So I'm not sure what that would do outside of vindicating Ohm in the public eye, what that would really do for his case. I mean, you already have stuff, you already have admissions here that I think are solid enough for him to take to court. So give me one sec. Let me bring up some more information here. All right, just getting something ready for this. All right, with an anticipate. Okay, let's skip ahead here a little bit. Other critical witnesses will include multiple members of plaintiff's personal and professional circle of Illinois who heard or read the defamatory post and thought less of the plaintiff as a result. Complaint at Paras 3770, 115, 140, 144. Those witnesses include Illinois residents. This is one of the girlfriends. This is the sex tape girlfriend, and this is a gentleman that works for a particular company, right? And that's the last one that is that is mentioned here. Illinois resident is CEO and co-founder of Leviathan Core LLC. Plaintiff alleges that that Ohmwrecker and Leviathan Core stop that he and Leviathan Core stopped paying plaintiff for sponsorships directly because of defendant's offending speech. Mr. This is the guy from Leviathan Core will currently be a witness in this matter. Now, we'll get to Leviathan Core in just a moment. I'm just going to finish off this document. So we'll continue on here real quick. So it says the defendant has also failed to show that the public interest clearly favoring transferring the case to the Eastern District of North Carolina concerning the length of time until resolution of a cause of action. The average time for filing to disposition is significantly less in the Northern District of Illinois, 7.2 months, than the Eastern District of North Carolina, 11.6 months. Showing the most recent data available through June 30th, 2022 for these two districts. The factor also weighs against transfer venues not proper for Eastern District of North Carolina, but even if there were another acceptable form to succeed in this motion to transfer, defense counsel was required to show that the private and public factors strongly favored transferring the case, a high bar. Ultimately, as the defendant failed to establish that the balance of the private and public interests strongly favor a transfer, the motion must be denied. Wherefore, the plaintiff, Ohmwrecker, respectfully requests that the defendant's motion to dismiss and or transfer venue be denied in full. So there you have it. Now, the stuff down here that I'm about to show you, okay, because one of the things that Ohm was claiming was that as a result, he in his filing, there's also tortious interference. He claims that he essentially lost money. He lost his sponsorship deal as a result of what was going on with Delirious. And there could be some truth to that. But as far as damages go, I'm not sure how much you're going to prove in the way of damages there, because the company that he mentions, I'm going to show you all this real quick. The company that Ohm refers to, Leviathan Core, makes it seem like it seemed to be like a big deal. I want to show you all this real quick. And if you guys look Leviathan Core up, this is Leviathan Core. Look at the following here, okay? This is a company, Leviathan Core is a company of only 8 employees that I saw listed, okay? If you look them up on LinkedIn and stuff, it's not a huge company. So I can't imagine that if he did lose some kind of sponsorship deal with them, that it would have been a substantial amount. These are, maybe these guys are well connected. Maybe they don't have to worry about having a large following online. But it seems like I said, at least on a surface level look, I've never heard of them. And I'm not saying they're necessarily small potatoes. Like I said, maybe they're very well connected and we just don't know how well connected they are. But I can't imagine that, and maybe I'm wrong. I'm just, I'm purely speculating here. I can't imagine that whatever sponsorship deal that was lost with them would be like, you know, I don't think it would even be something in the 5 figures. Maybe I'm wrong. Maybe it was. Maybe it was in the 5 figures. Maybe it was in the 6 figures. Who knows? But given the fact that it's a company that of only 8 employees, and I can't seem to find any, and maybe if I dig deeper, I'll be able to find, financials for them to see what their net worth is. Never heard of them. Don't know who they are. Supposedly they're based, it seems like from what I saw, it's supposedly based out of Illinois, but I saw that they have employees that don't live in Illinois. So I don't know. I don't know if their primary headquarters is in Illinois or what, if they're purely like an online company. I don't know the full extent of what's up with them. So take that for a grain of salt. So who is winning, who is losing? I don't know. Honestly, it's a stupid lawsuit. It's a really, really dumb lawsuit. I'm just interested in seeing how things play out, but it is a pretty dumbass lawsuit, if I'm being honest here. I think it's one of the stupidest lawsuits I've ever seen. It's just, it's really dumb. It is really, really dumb. All right, so let me see if I can. All right, I'm going to bring this back up. Now, in this filing, this is one thing that I think to me was very, I don't know what's up with Ohm's new attorneys. All I know is that they're going to make a lot of money off of him because this was like a 95-page filing. Okay. It was here. Exhibit A, defendant's girlfriend, Liz Cat, admitting the Twitter profiles that published the complaint of the defamatory speech were created by her boyfriend, H2O Delirious. We know about that, right? These are the ones. These are the ones that we know that were admitted to. Exhibit B. Now, this right here, you're going to see a lot of redactions, okay? Leviathan Core works with 2K Digital, Extremes, and more. Okay. Yeah, it seems like they work in like more of a behind the scenes, like marketing type of capacity. But like I said, they probably have connections in the industry, but they're not, I don't see them as being, they don't seem to be exceptionally large. So I don't know what that deal entailed, how much he actually lost. He hasn't put a monetary value on it. So we'll have to wait and see. But this right here, just so you all know, all of these redactions are because this is one of the this information was the girlfriend that that was apparently in that is alleged to have been in that sex tape. Okay. I don't know why his attorney saw the need to basically put her entire life story up on here. This has everything from financial information to her vehicle information, vehicles that she owned, to even court cases that she's been a part of. I redacted any kind of identifiable information. I went through the painstaking effort to do that, to not show anything personal about this woman. I see no reason to put any of this in. I guess it's to show that she exists, that she's a real person, but I don't see why you would need to go to this extent to essentially put out her entire life in this filing. So, and this is stuff that's going to cost, Ohm more money. Like if his lawyer's putting in more stuff in the filings, that costs Ohm. So it's just like, I don't see why you would need it. To me, this is not relevant. This is not relevant at all, unless she's filing some kind of, exactly. This is exactly what you just said. This is exactly what this is. Padding out the paperwork. That's all this is. This is just them padding this filing, by putting all this stuff in. None of this, in my opinion, is relevant to anything regarding Ohm, but it's all here. This is this woman's entire life story, documented life story put into this. And mind you, this is a girlfriend that Ohm dated, 17 years ago. There's no need. the thing is, they don't need to really put all this stuff. This is not relevant to anything. What her homes were worth, homes that she had were worth, what vehicle she had, what court appearances she had prior to that is not relevant to anything. She's not the one that's, you know what I mean? She's not the one that's suing here. So this is all this is, right? To me, this is just, they just padded this filing. Look how many pages this is, 46 of 75, plus the other pages, that I should already, but this one right here, this filing alone was 75 pages. Look at this. That's all the stuff I had to redact, to protect this person's identity. So, oh yeah, basically, yeah, there's stuff in here that, again, there's the woman's phone number, her current address, all that stuff. It's all in here. It's just like, none of this is important. Like, none of this is relevant to the case at hand. Like I said, I'm thinking, all right, well, maybe they just posted this to show that she's a real person, but you didn't have to take 75 pages to do that, to show that she's a person that actually exists, right? Because none of this other stuff, this is all fluff. None of this is stuff that anybody needs to know about this woman. Look at this. Even people associations, right? Like, why does anybody need to know any of this stuff, right? Why does this need to be in a court filing? It's ridiculous. And then here, this is the co-founder and CEO of Leviathan Corp. I'm sure this is information y'all could find for yourselves, but in the interest of, making sure that this person is not harassed or anything like that, I went ahead and redacted all their information too. See, but this is all their information as well. It's just like, none of this is relevant. Like I said, I think there's other ways to prove that these are legit people without posting this kind of information. But that's just me. All right, so this is what we'll go ahead and finish off with for the night. So, yep, exactly what Bowsette is saying here. Pages equals time, equals money, and hope that they nickel and dime him out. Yeah, that's the only reason I would see to post all this shit, is because they're trying to basically squeeze Ohm for as much as they can. You know what I mean? Maybe he's happy to pay that, but if I was Ohm, I'd be like, why are you posting all that information? Just post the stuff that proves that she's a legitimate person, or let's just try to get a declaration from her and file that. To me, that would be much more, in my opinion, that'd be much more effective than posting this woman's entire life story, right? Her entire paper trail, cars that she's owned, her license number, all that stuff. None of that to me is relevant. Like I said, but maybe, I don't know, maybe they have some kind of different strategy in mind that I'm just not seeing, or maybe it's something that is maybe it's not something that's irregular, that's all that irregular, I should say. Maybe it's, like I said, maybe I'm just misunderstanding what I'm seeing here, but I just like, what the fuck does this have to do with anything? So this is what we have. This is the most recent filing. This was, Delirious's, his motion to dismiss. And this is the most up-to-date find that we have so far. So anything after this will be new once I get a hold of that, but this is the most recent one. This was earlier this month, okay? So we have here proposed order granting motion to dismiss complaint for lack of personal jurisdiction in proper venue, or in the alternative to transfer venue of defendant Delirious. The court has before it the motion to dismiss complaint for lack of personal jurisdiction in proper venue, or in the alternative to transfer venue of defendant H2O Delirious, and considering the merits of the motion, plaintiff's response in opposition thereto, defendant's reply in support of his motion, plaintiff's reply in opposition thereto, and all other papers, evidence, and arguments submitted by the parties in connection to the motion to dismiss, being familiar with the file and a record of this action and of the basis thereof, it is ordered, adjudged, and decreed the defendant's motion to dismiss shall be and hereby is granted, and that the action is hereby dismissed under Federal R Civil Procedure 12B2 and 3, because the court lacks personal jurisdiction over defendant for improper venue. Alternatively, it is further ordered, adjudged, and decreed the defendant's motion to transfer venue shall be and hereby is granted, that this action is transferred to the United States Court for the Eastern District of North Carolina pursuant to 28 U.S.C. 1404, 1406. Okay, so to break it down, what does this mean? This means that the motion to dismiss under jurisdiction was granted for Delirious. That means that Delirious does not have to go. And this, not that I'm saying he would have necessarily even had to leave the state of North Carolina. Maybe they would have done like a Zoom court appearance or something like that. But basically what this means is this case will not be tried in Illinois. It will be tried in North Carolina. So the case has not been dismissed. What was dismissed was, essentially, the jurisdiction is basically just a transfer of venue. It has the case itself has not been dismissed. This just means that instead of the proceedings happening in Illinois, they will instead happen in North Carolina. So basically, I guess you could look at that as Delirious is going to have the home field advantage, but I don't know if he'll actually have a home field advantage because now it all depends on what kind of case is going to be presented by his attorneys, how they're going to argue stuff. But, if there's a court appearance that has to be made, like a physical court appearance, it'll be done in North Carolina, but I'm sure that they'll find, they'll probably argue to do it maybe, over the internet or whatever. But, if there is a deposition, though, I do believe, and I could be wrong about this, but if there's a deposition, I think that's something that Ohm will have to travel to North Carolina for because he'll probably be ordered to do that because I don't think depositions can be done through. Maybe they can. I don't know because each state is different. I'd have to look it up. So don't take my word for it. So I could be entirely wrong. Typically, depositions are done face-to-face. They are recorded usually, most of the time. Unless the parties agree to have it done like privately behind closed doors, then there's usually just a transcript of those. But if they both agree to have it recorded, which I don't see any reason why either one of them would, if they're so concerned about their anonymity, I don't see why either one of them would agree to have it have it be video recorded. So it'd be probably something that would happen behind closed doors. There would probably be a transcript of it. So that's what we'd probably end up getting as far as the deposition goes. Or maybe an audio recording if they decide to have it done, recorded via audio. But I don't know if they would actually require Ohm to be there in person. I mean, usually those things are done like that. They're done in person, but due to, the COOF, there might be rules that have changed regarding that. So I just, for now, we'll just have to wait and see. But for what we know right now, things are being transferred to North Carolina, which is one of the things I guess that, Delirious's attorneys wanted. They feel maybe they feel they have more of an advantage in North Carolina, access to witnesses, etc. We'll have to wait and see. I would think that if any of the people that were mentioned by Ohm in the previous document are going to be people that speak on his behalf, we'll probably see, either declarations by them made or some kind of affidavits filed that will be put into future filings. And honestly, we'll have to wait and see what comes out through discovery. Maybe there's stuff that Ohm's attorneys are withholding, and that's why they weren't part of this filing. Because remember, like I said before, there's stuff that, at least that I hadn't seen publicly, doesn't mean that it doesn't exist. Even though I said, hey, I don't see any proof of this. I haven't seen any proof of this, but it's not to say that it doesn't exist. And maybe that's an ace up their sleeve, right? Maybe that's something that they're waiting on. Okay. Hold on. They denied the motion. Hold on. Because I think that I had the most up-to-date filing. Hold on. Let me check to see. It will be in Illinois. Let me check. TJ says that they denied it the next day, so I have to see. Let's see. Hold on. Let me look. Let me check my DMs. I believe, yeah, I think TJ did send me something before. Give me a sec. Let me look and see. Let me see. Okay. Oh, I guess it was. Hold on. Why wasn't that in the filing that I saw? Hold on. Let me see. All right, hold on. Give me 1 sec. I'm looking over the document. Oh, wait. Yeah, I think TJ's right. I think I did see this before, but I forgot about it. Hold on. Okay, I would have to redact this. Okay, so I stand corrected. Yeah, it looks like. Okay. Yeah, it looks like it was denied after the fact. So it looks like it will take place in. So there won't be a transfer of venue. Legal standard plaintiffs bears the burden of proving personal jurisdiction when challenged. If personal jurisdiction. All right, I would have to redact this if I go over it. Why don't I have this in the filings here? Okay, so I stand corrected. Looks like, yeah, the very next day, I guess they changed their mind. They changed their minds, and it looks like it will be argued in Illinois. So we'll see if that gives Ohm any kind of advantage. It'll definitely make it easier for his witnesses to, let me see, dismissed for improper venue. It'll make it easier for him to get his peeps on board, I guess, there. But all right. It's interesting. There's some other things that are argued here too in regards to Epic Games. Let's see. And yeah, like I was mentioning before, it looks like what would happen here. And I would probably have to, if I'm going to go over this, I'll have to do some redactions on it, because the people that were shown in this document, the one that I just showed you all, would be people that I guess Ohm's attorney would plan to call as witnesses. Though I think it's only specific people, though. I don't think that. Let me see. I'm just looking it over here real quick in real time. It's just for the state. North Carolina, this community has a close relationship. The claims involve the alleged injury to plaintiff arisen from the form state. Illinois has a strong interest in providing. So yeah, it looks like it's denied, which is weird because it literally flipped on a dime from one day to the other. They granted the motion. Then they granted the motion to transfer the venue, but then they denied the motion. Then they denied both. They denied both the very next day. So there's no filing in between that I see. But it's interesting. I wonder why they decided to, or why the judge decided to change her mind on the ruling. Maybe she got a chance to read through more of the documentation. Maybe she just changed her mind. It's hard to say. See, and this is what I mean when it comes to these court cases, is how let me see. So let's see. Yeah. So see, this is what I mean with these court cases. They kind of go. They can go anyway. So the filing number for that you have up in the screen was proposed or it was never official. Yeah. Yeah. No, I see that. But usually, when it says ordered, judge, and decreed, it's almost a foregone conclusion at that point. But yeah, looks like they decided against she so and she didn't sign this one. So yeah, it was just proposed. Yeah, stand corrected. So yeah, I see it now here because she never signed it. I stand corrected. Yep, that's right. Yeah, she never signed she never signed this. So I do stand corrected there. Let me see. Where's my latest filing here? Okay. So yeah, this is gonna be wild. So it looks like yeah, so it looks like they were basically that's what they were hoping for, but yeah, it didn't go anywhere. Honestly, they should have argued from the very beginning though, just to get it dismissed outright. But see, this is what I mean. Like, there's a poor job being done on both sides here, I think. But yeah, this is not. Yeah, this is something that will probably, I mean, at least surface level, it looks like it might favor Ohm a little bit more at this point. But again, it's hard to say because just having it in your state alone doesn't guarantee anything. One would think that it would give you the home field advantage, which in a sense it could. Like I said, it'll make it easier. Like I said, access to witnesses, things like that, for people to come in and do their depositions because they also live in the state. That'll help, especially the two people that he plans to call, which would be the Leviathan Core CEO, as well as one of the ex-girlfriends is probably the one that is, the sex tape one is probably going to be one that's called in for deposition, or at the very least, they're going to have filings. Either they're going to do declarations or they're going to sign some kind of affidavits if they're not going to appear. As far as the other girlfriend is concerned, the one that Delirious did name that he did actually dox her first and last name of, I don't know if she'll be a part of any of this, but don't be surprised if there's a filing there. But it seems with that particular girlfriend, and this is separate from the sex tape girlfriend, it seems like they're more concerned about protecting her identity. So I don't know if she's going to necessarily want to be involved in any of this, because it seems like they went out of their way more to redact her information and protect her, because there's a filing that they made separate for her that they protected her identity with. So I don't know that she'll file anything. She very well might, but at least for the time being, it seems like for sure, or more than likely, it's going to be this Leviathan Core CEO guy, as well as the girlfriend that was, in the that was in the tape. So we'll see. This is going to be pretty wild. Like I said, this is the thing about court cases. This is what makes them so interesting, is that they could go either way. They can really go either way. It's going to be a tough one. It's going to be interesting to see how it plays out. But I would say there's been some big missteps already, just the way they've been handling it. But yeah. Yeah, so yeah, this is the part I completely overlooked here, and this was my bad, was that this was not signed. So thank you to TJ for pointing that out. Appreciate it. Stand corrected. And like I said, maybe I'll go over this latest filing. But let me see. Oh, this is interesting. So in this filing, separate, this different from the other filing, is that This one alleges the Hopper 98 account to be Delirious, whereas the other one doesn't make that distinction. So that's pretty interesting. It seems like for this filing, it seems like a lot more, at least on a surface level look, that there was a lot more care put into, I guess, trying to be specific on certain things. So that's interesting. So as far as how it goes, the more in a lot of these cases, the most likely scenario is some kind of settlement. So it just depends on who's feeling froggy enough to fight it out and for how long. So a settlement is a very real possibility. With that, the strings attached to it can be that what ends up happening is that they just, as a part of the settlement agreement, that they never talk about it, either one ever again. They basically, a certain amount is agreed upon, and it's basically like delete everything that you put out there about me if you haven't already, and don't ever talk about me again. Because that's what we saw with the Zero versus Jisoo case, right? It was basically like, delete everything you said about me, everything that you put out there about me publicly. You go your way, I go mine. Don't ever talk about me again, and I'll never talk about you again. So it'll be interesting. So, looking forward to seeing how this thing shakes out. Yeah, that's the one thing about court cases. They honestly, no matter how much you think that you or have an idea of how you think a case will go, it rarely ever goes that way. Because with the Zero and Jisoo case, what was interesting about that was that Jisoo basically took this hardline stance that no matter what, she was going to fight it out. Remember, she said that, hey, I'm willing to die on this hill no matter what. I am not going to back down. And what ended up happening, the first opportunity that she had to settle, she 100% took it. After all that bravado, right, of saying that she was not going to be essentially saying that she was not going to be silenced, that she wasn't going to back down from this, that she was going to be like this voice for the voiceless. The first opportunity that she had to settle, she 100% took it. So that's what I mean. Like with situations like this, no matter what anybody says, you can't really rely on what either party says in this situation or how much they say they're willing to fight stuff out. You never know who's going to fold first. Ohm could end up folding first. Delirious could end up folding first. We don't know. We'll have to wait and see. It just depends on how things go. I will say that I think that I definitely have criticisms towards both sides of how attorneys have handled certain things, like especially Delirious's attorneys. I think that they honestly should have countersued from the very beginning and basically put out there that, hey, this guy defamed me first. He's the one that threw the first punch. He was saying these things about me. And even though it'd be a hard thing to argue, I think his attorneys could have said, hey, listen, my client did some things, but he did them in retaliation to this. And depending on how you make that argument, and how compelling that argument is, or how understandable that argument is, you might have something there. It's like, the only reason he took this stance was because he was being attacked this exact same way first. And you could see it here. Here's the timeline of events of how things happened. Okay. He said this about me. He said this about my client. He essentially called my client a predator first, and all sorts of defamatory things first. And my client, in his poor judgment and his lack of good judgment, decided to retaliate the same exact way in many instances. So I don't know. It's dumb. This whole thing is really fucking stupid. There's really no other way for me to look at this. You know what I mean? Than say it's a really dumb case. It's one of the dumbest lawsuits I've seen in a while. And I really don't know what's going to happen. Like I said, yeah, Delirious might have given, um, you know, he might have given Ohm enough to bury himself, but at the same time, like I said, I think that there's enough that Ohm gave Delirious too to kind of bury himself. But it doesn't seem, and maybe some of you will agree with me, maybe some of you won't, but it doesn't seem like Delirious's attorneys has effectively, they've effectively used the stuff that's out there as well. You know what I mean? The stuff that Ohm has put out there, it doesn't seem like they've used it as effectively, which is like, it's right there. It's right there on a silver platter for you guys, So I don't know. I don't know what's going to happen, but this shit is crazy. Anyways, I think I'm going to wrap it up right there. Thank you all so much for joining me this fine evening. Thank you, TJ, for the document. Like I said, it might be the last one I go over after I do some redactions on it and stuff. And thank you for the corrections. I appreciate it. I'm usually pretty good and thorough about looking over stuff, but hey, I'm only human. I overlook stuff and get stuff wrong sometimes, but I'm never afraid to admit it. You know what I mean? So I appreciate that. And like I said, I'll be going over this next one with a little bit more of a fine-tooth comb than this previous one. So I'll be looking it over. I'll be doing the proper redactions, and maybe we'll go over this one this week coming up. But I'll have to wait and see, because there's some interesting stuff that's argued in this one as well. So, and it seems like there was a lot more specificity when it came to certain things. So it'll be interesting to go over this. So appreciate you all joining me. You all have a wonderful night, a happy new year. You all take care.